May it please your Lordships, I have spoken to the applicant, and the prayer of the applicant is, Lordship, at least one G+6 may kindly be allowed. The building permit as per the AMC is G+7. So at least G+6.
How many floors is coming after the road?
Lordship, after the road, if it is G+6, only one floor, a road level and then one floor.
That means 4 floors below the road.
No, 5 floors.
Yes, 4 floors below, 5th is road level and then one floor above.
Oh my God, probably or not.
G+6 is 7 floors. Too high.
Even if we allow the goal level, I think that at least they'll still have that tradition.
Yes.
My Lord, my humble prayer was for this IA, my Lord, not to be even if it's disposed of. This is my humble prayers, my humble prayer, my Lords, that let this construction not continue. Let this full-fledged construction, at least, my Lords, let it not continue. If they want to do a retaining wall, that's a different matter, my Lords, because the problem is, since 2024, there has been no landslide. Now till 2024, there were massive landslides happening in that area. Now, why has these landslides not happened, my Lords? Is because this court issued a stay order. There could be no other reason. So this is my humble prayer, my Lord. Let this matter, the entire matter, be taken up together. And there are also, my Lord, three people who have violated the stay order. And their names are reflected in that spot verification report which has been mentioned. So their case also has to be taken up. So, my Lords, if he is allowed to construct, what will happen to all?
What 3 other persons?
If your Lordships will see the affidavit filed by the by the AMC, respondent number 8, they have enclosed the verification report. Now, in that they have mentioned, my Lord, that there are 3 individuals who are not impleaded in this case who have violated the stay order.
Violated the stay order?
The stay order issued by this court. My Lord, it issued a stay order on the first day. That stay order has been violated by these 3 people. And they have not been impleaded as parties till today.
Who are these persons? Give us the names.
Yes, my Lord, their names are reflected at page number 6, my Lord. Page number 6 of the affidavit submitted by the respondent number 8. AMC.
We dated.
My Lord, this one is dated. My Lord, the date's not given in my copy. So, my Lord, this is the last affidavit.
When was it submitted?
My Lord, this was submitted in the month of March. This year. Respondent number 8. It's a small affidavit, my Lord. It's a very, very small affidavit.
Ninth of March.
9th of March, my Lord.
It's not a reason.
In fact, 5 of them have violated, but 3 of them are already parties in this case. Sorry, 6.
Where is that?
My Lords,
In the IA, Lordship, it's in the IA.
it's in the IA.
Okay, it's in
The
there.
IA, the affidavit submitted by respondent number 8.
Paragraph or
My
which
lords,
page?
my lords, page number 6. My lords will see B, violation of court order. There it's mentioned, my lords, 6 people. My lords, at page number 6.
9th of March.
In mind, the date is not given, but it's written March, my lord.
This one, 9th of March. This one. Joining
Page
section.
6.
This one.
My lords will see page number 6B, violation of court order. The following individuals are found to have initiated new construction.
Violation of which court order?
My lords, order in the first order passed by my lordship.
I will initiate contempt against him. What do you think, brother? Throw.
Let us see the order. What order was that?
My lords will see the order dated
July 2024 in the PIL.
the first order.
18/7.
My lords will see paragraph number 12. There is a clear stay order issued by this court.
No, one thing is there, after this paragraph 12, was there any such kind of order, notification, information
Yes. My lord,
issued
yes,
by the AMC or who's the authority?
definitely, my lord. That is the reason why respondent numbers, the applicants have not been constructing. They have stopped construction. These people, my lord, they were all.
Where is that? Where is that?
My lord, I think the state government will be will be able to answer this, my lord.
these 3 persons will not be personally getting that copy of the court's order. Some authority has to inform them, isn't it?
I think yes.
Yes, where is the, what has been done?
Because my lord, paragraph 13, the municipal commissioner, the deputy
But the
commissioner.
AMC is supposed to take care of this. What order have you issued pursuant to this 18/7, 2024 order for stay?
It will be page 5 of the state affidavit, dated 18/9/26.
Page 5.
Page 5. DMC has passed the order dated 19 July 2024.
Ah. Okay, right. I don't know now, I think we'll have to enlarge, maybe we'll make a suo motu contempt, let them file their reply, let's see if there's any contempt made out.
Lordship, if your Lordship is going to impede these people,
No, we're going to initiate contempt first.
yeah, it may come in the main PIL.
Which one? No, but we'll reflect in this IA, because this is part of the IA. Right.
In the main PIL, the state have filed the affidavit stating the same thing.
Lordship, if your Lordship will see the order dated 22nd October 2025 in the main PIL. 22nd October 2025. The main PIL.
That's in the main PIL.
Yes, 27 October 2025.
Can't find that. 22nd October.
There is no 22nd October.
Last order is 7/5/25.
My lord, this was.
There is the 3rd October 2024. You are talking about 2025?
Yes, Your Worship, 2025.
They refer to this thing, in compliance of direction dated 22/10/25. I can't find that.
There's an order passed in the main PIL on 22/10/2025.
What is the order? What does it say? We are not being able to see that order.
To
It's not
conduct a
available.
Ah, yes,
for
yes,
the
yes.
application.
67. My copy has only 60 pages, 61 pages.
In the main.
They have not made second copy. Anyway, what was it? Sport verification.
G plus 5 is too much. G plus 4 plus 6.
This report is in persons of the order dated 22/10, passed in the main PIL.
Codemaster. Please ask the registry to ensure that they should keep extra copy of this
Correct.
in the second file.
Heard Mr. In the IA, A.R. Malhotra, learned counsel for the applicant, who is the respondent number?
9.
9 in the PIL. This is an application praying for allowing the applicant / respondent number 9 to construct his house on the basis of the permission given by the AMC Next paragraph. The applicant's counsel submits that the AMC has given permission to the building plans of the applicant for construction of a G plus 7 building between two buildings which are already standing on either side of the applicant's land. Full stop. Mr. Joseph L. Rentley, the learned amicus curiae, on the other hand, submits that there are other persons whose attempt to construct buildings and those who had constructed up till the first floor submits that a stay order had been issued by this court on 18/7/2024 to stop to not allow any construction and stop any construction activity that had not surpassed / completed one floor in the Bongkon Dutlang Layton Road. So, he submits that the order passed in this application would also have a bearing on the persons who are attempting to construct building on the said road. Full stop. He submits that, in fact, there are 3 respondents. How many in this period?
Three respondents. And
3 respondents. Who are respondents number?
my lord, one is respondent number 13. Respondent number 13, 1 minute, my lord. Respondent number 15. And respondent number 16.
And respondent number 16, comma, beside the respondent number 9, who would be affected by the order passed today. He accordingly submits that the entire matter should be heard and disposed of, and not dispose of the present application in a piecemeal matter.
Correct, my lord.
Full stop. Mr. Yar Malhotra, the learned counsel for the applicant / respondent number 9, submits that after consulting with the applicant, he has been instructed to say that the applicant will not construct beyond G plus 6 floors. Full stop. We have heard the counsels for the parties. This PIL had been initiated this suo motu PIL had been initiated due to numerous landslides having occurred on the Bongkon Dutlang Lathan Road due to indiscriminate earth cutting from the steep cliff along the side of the road. This had affected people in Dutlang and Aizawl during the entire monsoon season of 2024. Accordingly, while taking up the matter on 18/7/2024, this court had passed a stay order in para 12 of the said order, dated 18/7/2024, as follows. Next para. Subsequent to the said stay order, dated 18/7/2024, the AMC had issued order dated 19/7/2024 to the following effect. I'll put this blue. Okay, in the IA.
Page 5.
Page 5 of the IA. Next. Thereafter, affidavits were filed by various authorities and the intact and the petitioner. Don't say so motu, don't say so motu. Cut that so motu. Just say PIF. Okay. The order dated. This court thereafter passed order dated 22/10/2025 on being informed by the learned amicus curiae that numerous constructions had been made along the said road in violation of the order dated 18/7/2024. And accordingly, this court had directed the AMC, the respondent number 6, and the representative of the petitioner to make a spot verification with regard to the said information brought to the notice of the court. Next paragraph. Subsequent to the above order dated 22/10/2024, a joint inspection was carried out, and the report of the joint inspection team was to the effect that the following 6 persons have violated the order of this court dated 18/7/2024. the names of the 6 persons, comma, mentioned in the joint inspection report are as follows. Page 6, page 6. In the same affidavit, okay, in the same affidavit, page 6, here down.
Your Worship, if I may, the report very clearly says that we have abided by the court's stay order. Para 2.
No, you are not here, no?
We are here, Your Worship. Para 2.
You are here.
Para 2. Compliance with court order.
No, at least
No,
they
I'm saying those who have not complied.
Yes.
so violated.
I'm just bringing to your Lordship notice that this
Yes.
report says that we have complied with the order.
Okay, no problem. Next. Considering the fact that the above noted 6 persons have violated the court order dated 18/7/2024, we are of the view that a contempt case, a suo motu contempt case, should be registered against the 6 persons. Accordingly, registry is directed to register a contempt case against the above noted 6 persons by making the petitioner in the present case also the petitioner in that contempt case. The contempt case should be listed on the next date. That is on on 8th. No? On 8th. 8th or 1st? First. On 1/4/2026. So this for issuance of notice basically. Don't say anything, that's all. Next paragraph. So brother, what do we do? We come to this G plus 6 is
This is the same report. It's 3 violators, or is it this paper will be allowed?
But then we are going to allow 6 reviews on they were to block the ski and who
बोला खाली इन दिन से होता है इसको करने का सका हम छोड़ते हैं रोड लेवल तो नहीं सकता
We'll allow you till the road level. We'll give G plus G
Plus 5.
G plus 5.
Up to the
That
road.
also is a special case.
You have a neighbor out there, both sides.
Pardon? Yes.
You have neighbors,
Both sides.
they're already there.
Yes.
They're already on the road level.
They are only on the road.
You have not reached the road level.
Not.
They have not started.
Pardon?
You have not started.
I have started, Your Worship.
First floor.
Pillars have, 1 or 2 pillars have
Next
already.
para. It is interesting to note that the regulations that are followed by the AMC prior to giving permission/permits to construct buildings in Aizawl town, in Aizawl, within the Aizawl city limits, does not have any restriction with regard to the number of floors that can be constructed. We find the same to be very
practical.
we find the same we do not find the same to be reasonable, keeping in view the topography of Aizawl city. While some parts of the city may have some level land, other parts of the city have very steep cliffs, and as such, the requirements to be provided to a house would vary, depending to be provided by the municipality and the various departments to a house would vary, depending upon the locality. Further, when houses are constructed, when 5, 6, 7, 8 storied houses are constructed, some of the floors are usually let out on rent, and that puts a strain on the facilities to be provided to the said building, civic facilities to be provided to the said building by various authorities. Full stop. The soil within Mizoram being alluvial soil, no? Alluvial.
I think
It's alluvial soil. Yes, Mr. AMC. What is the soil?
Madam.
What is the soil within Mizoram? Alluvial soil, I think. You have got no idea. Okay, being alluvial soil, come on. It is not practical to have
But the height limit is restricted to 19 meters.
90 meters.
19, 19.
19 meters.
64.4 feet. It would be approximately about ground plus 6.
See, since it's not a level place like plain areas, so the number of floors would depend on from where you count your ground floor, isn't it?
Yes, my lord.
Ground floor can be down there in the valley.
So, how many, the height limit is how much?
As per regulation 39, sub number 2, the height limitation. The height of a building shall be restricted to 19 meters.
19.
19.
19 meters is how many floors? How many feet? How many feet?
64.4. 64 feet, 4 inches.
Okay.
Six floors.
So we will say that the building to be constructed by so and so should be G plus 6, provided it is within
19 meters.
19 meters.
19 meters.
So what have we said? Huh? What? In the? Ha, ha, ha. It is not practical to have very
The regulation number was very high.
tall high rises. Besides the fact that the whole of the state is within the highest earthquake zone in India. Full stop. Next paragraph. Mr. Zoram Chana, the learned counsel for the AMC, submits that the height limit of a building as per
AMC building regulation.
the maximum height limit of a building as per the AMC
Building regulation
building regulation 2012 is 19 meters, which is approximately
64 feet, 4 inches.
64 feet 4 inches. He accordingly submits that no building can be constructed beyond 64 feet 4 inches. On considering the fact that the applicant's proposed building is to be constructed between two already constructed buildings, and keeping in view the the oral undertaking given by Mr. A.R. Malhotra on the basis of instructions received by him from the applicant, that the building would not be constructed beyond G+6 floors, we dispose of the present application by allowing the applicant to construct his building to construct a G+6 floor building. First up. However, the said approval granted shall be limited to the total height of the building of 64.4 feet.
Oblique 19 meters.
In the event the building is unintentionally or intentionally beyond 64.4 feet, the extended portion of the building shall be demolished by the applicant, and if the same is not developed by the applicant, the same shall be demolished by the AMC, and the cost of the same shall be realized from the applicant.
Joint verification, joint site inspection.
Okay. A joint site inspection, 6/2/2026.
My lords, if I may point out one thing, among those 6 violators, my lords, 3 of them are impleaded as respondents, and 3
Okay,
of them are
you just
not
write, it is also been brought to our notice that Dr. Valal Roy is respondent number?
No.
Who are the respondents?
1, 5, and 6 are not impleaded, my lord.
1, 5, and 6. Also brought to our notice that Mr. Lalram Siyama, Lal Liana, and Lalram Sanga are respondent numbers
13, 14, and 16.
13, 14, and 16 in the PIL respectively.
Sorry, 13, 15, 16.
13, 15, 16 in the PIL respectively. The Dr. Vanal Roy, Lal Lamzwali, and Lal Ram Thanga are not impleaded as respondents in the PIL. We are thus of the view that the above 3 persons should also be impleaded in the PIL registry to implead Dr. Vanal Roy, Lal Lamzwali, Lal Ram Thanga, who are mentioned in the joint inspection report as respondents number
26, 27, and 28.
26, 27, 28 respectively. A corrected copy of the cause title should be prepared by the registry and inserted in the main PI.
Obligement.
The I is accordingly disposed of.
I'm obliged.
One more thing you just write. Further, the proposed construction does not lie within the reserved area.
Protected zone.
Lies outside the protected area.
Does not lie inside the protected area of the Dutlang, the Bokwan Dutlang Road. Let's put that, huh, sir?
Please, Your Lordship.
For admission, item number 1.
My Lord, I beg to mention one item, my Lord, item number 3, my Lord.
Yes?
My Lord, so far, my Lord, the paging is concerned, my Lord, my copy may not be matched, my Lord, because some in index and my Lord, the paging, my Lord, paging of item, my item, my Lord, 3, my Lord. My index, office copy index and others, my Lord, some discrepancy is there, my Lord. So, my Lord, it may be a problem, my Lord. So, may I pray, my Lord, I will be allowed to some time, my lord, to obtain a certified copy of the court copy, my lord, because there is some, my lord, today morning I have seen, my lord, there's some discrepancies there.
Who is in item 3?
My lord, I am this first, this no notice not issued, my lord. This small issue is there, my lord, regarding on clause 10cc, my lord. This, as per our view, is not applicable, my lord, and which was in agreement is deleted, my lord. And so far, there is a general GCC 2007, my lord, clause 10cc is applicable, my lord. But as per the contract is there, my lord, contract agreement is there, the 10cc is not applicable. This is the issue, my lord.
No, this is, item 3 is a arbitration application, appeal.
Yes, my lord, item 3, arbitration application 2 of 2025, my lord.
Arbitration, no, why have you given me WPC? That is item 1. You wait, we'll see.
Yes, ma'am.
You wait, yes, no, it's okay. No, we'll start with item 1. Yes, item 1.
Lordship, I'm appearing on behalf of my senior, Mr. Sridhar Ramazawa. Lordship, we would like to seek another 2 weeks' time to file a reply to the additional affidavit filed by respondent number 527, EPIL.
Yes, what is the problem here? Yes, madam, what is the problem? Have you read the case? You've got no idea. What? What is the case about? You all have not read. Okay, right. On the prayer of the petitioner's counsel for what? For filing?
For reply to additional affidavit of respondent number 527.
Just right. The petitioner has not filed a reply to the affidavit filed by the respondent still. They are granted a further, how much time?
2 weeks' time.
2 weeks' time. Release them out after 2 weeks.
Oblige.
Item number 2.
May it please your lordship.
Just a minute.
My lord.
Yes. Yes, Mr. So there was a compensation amount. Initial compensation was how much?
My lord, the initial compensation was 12 lakhs 72,480.
480.
Yes. 12,7.
And subsequently there was a reassessment made.
Yes.
On what basis?
My lord, if your lordship will kindly come to page number 34. Page number 34. This is the assessment of the value of fruit, crops, vegetables, so and so. In the table, it is given. However, my lord, the rates of such crops have not been provided.
Rates not provided.
Yes.
And so how did it, so how much is, what is the amount payable?
The amount
No.
payable, according to this assessment, the total comes to 68 lakhs 26,353.
50?
68 lakhs. 68 26,353.
Where is that?
My lord, this will come at from page number 43, 44, and 45. Page number 43, 44, 46,
43, 44,
and
40?
45. 45.
Okay, so you have been asked now to pay the 68 lakhs.
My lord.
So the 68 lakhs is not inclusive of that 12 lakhs. That's separate.
My lord, this is now inclusive.
At the 68 is
Yes.
inclusive of the 12 lakhs.
Yes, my lord.
So the 12 lakhs has already been paid.
My lord.
Correct?
So far as
So you
yes,
have
my
got
lord.
to pay another 55 lakhs.
Yes,
again.
53,873.
Now, Mr. Counsel,
Yes, ma'am.
page 43, 44, 45 is the amount payable, correct, according to you?
Yes, Lordship.
Now, let us see 43, come to 43.
Yes.
You see number 1,
Yes, Lordship.
Pulrua,
Mm.
quantity 65, correct?
Yes, correct, Lordship.
Then you come to number 2 at page 43, Pulrua 260 quantity,
Yes.
correct?
Yes,
Now you
Lordship.
come to page 34,
Yes.
there is only Pulrua 65. There is no Pulrua 260.
Lordship, that is between planted and fruit.
No, but then it should have been here in the assessment report. It is not there in the assessment report. In the assessment, there is only 60 Pulrua trees, that's all.
Yes.
But in the compensation payable, there is 65 plus 260, that 325 it will come to. Out here in page 34, there is only 65. Acha, fruit bearing, and acha, there are two of them. Okay. 65 and 260. Okay,
Yes.
okay.
Yes.
Fruit bearing and 1.5.
Yes.
Then Zongta 1 and Zongta 5. 98. Things open, that's it. How do you have so many fruit trees? I don't know, unbelievable.
Lordship, that the so-called reassessment was not a new development. Actually, on the first day of assessment, that is dated 16/3/2021, the major portion of the affected area, including the
No, Mr. Counsel.
Yes.
This has been done. When was the award announced? Pronounced? Award?
award was
Dated?
dated 15/3/2024.
15/3/94.
2024.
2024.
Yes.
When was the assessment made?
14/10/2021. That is the reassessment. Actually,
There's a reassessment.
yes.
The
fir-
award was made in 24.
Yes.
The award is passed by the learned arbitrator, my lord. After
Okay, this-
there were three assessments were made. First, The first
No,
assessment
no,
was...
where
yes.
is the compensation award, the initial compensation award of 12 lakhs? When was the date of that?
22/9/2021, Lordship.
That's what I want, not the subsequent one. Award 22/9/2021.
9/2021.
Then they reassessed.
Yes, reassess was conducted on 14/10/2021. The reason is, Lordship, two assessment was conducted on dated 16/3/2021 and 23/3/2021. The reason why
And 16/3/2021 and?
23/3/2021.
Yes.
Yes. The reason why two assessment was conducted is because the surveyor could not complete assessment on one day, because on the very first day, that is 16/3/2021, the major portion of the affected area, including substantial crop damage and property assets, has already been assessed. However, Lordship, on that day, the landowner not appended his signature in the assessment sheet, so that is why he was excluded in the 3G estimate. Actually, that reassessment is not a new development, Lordship.
No, you see, one thing.
Yes.
Now, in the 16/3/2021 and 23/3/2020, where is the assessment data sheet?
My lord, the assessment copy that has not been provided to the NHIDCL before the arbitrator. What was provided was only the final assessment
Of 14/10/2020.
Yes, yes, my lord. The respondent number one herein, before the learned arbitrator, had only produced, along with his application, only produced the assessment of 14/10/2020.
The assessment, the reassessment was allowed by whom?
Kala, Lordship.
Kala.
Yes.
But Kala's job is finished once it has pronounced.
My lord.
Once it has pronounced the award, what can it do?
Lordship, Kala has also accepted that the signature not appended is their fault. So,
No, but you see, one thing is, how can Kala consider an assessment made after the award? This 1272,480, 12 lakhs,
yes.
does it cover the cost of the crop assessment?
Only crop assessment, Lordship.
Only crop assessment?
Yes.
Then why, how can it be now again different? Yes, madam?
Yes, Your Lordship, I have been asked to represent Kala Khazoi. Your Lordship, as to my knowledge, Your Lordship, this aspect I have not really been informed about. I've only informed about the, based on the submissions made in the appeal, and I have been only informed in a in the very short time that I have been appointed, Your Lordship, that there were only two assessment done, which is on the 14/10/2021, and the other one is
23/3/2021.
Yes. So
Now, what is the difference between these two assessments?
Your Lordship, this assessment,
So, who is the arbitrator? Kala is the arbitrator, cannot be.
No, Lordship.
is the
Now, who directed the reassessment?
Complaint was made to the Kala, and
But his job is finished.
My lord.
but Lordship, Kala has accepted that it is their fault, so they conduct reassessment.
No, that's how can that be? His job is functus officio. Once the award is passed, he has got no role to play.
Lordship, complaint is also made to arbitrator.
But who directed reassessment?
Your Lordship, from what if I may, Lordship, from what I can see from the appeal, Your Lordship, the first assessment was done. However, there was no signature
Yes.
of the land.
That was, you see, the first and second was all right,
Yes, Your
but it was done prior to the award.
Lordship. Yes, Your Lordship.
Now, once the award is passed by Kala,
Yes, Your Lordship.
what role does Kala have How can he ask for a reassessment now? That is the case of him. Now the reassessment has been directed after award was passed.
Yes, Lordship. That is
And-
from the arbitrator.
Huh?
That is, I believe, Lordship, as per the appeal, that emerges only from the directions of the arbitrator.
Arbitrator, then he's saying Kala.
If I may take your lordship,
Is it reassessment is directed by whom?
my lord, if I may take your lordship to page number 31, this is the letter written by the respondent number 1 herein. Paragraph B, in the last line, it says, as a result, the reassessment was made on October 14, 2021, in pursuance of the then deceased order. However, this DC order was not annexed along with this application.
There's
Lordship,
something very perverse here
Yes.
going on.
and there is also, my lord, after compensation release order was issued by the
Compensation release
Release
order
order-
issued when?
on September 22nd, 2021. This is also
September
22nd, 2021. This is also reflected in the application of the respondent number 1 here in paragraph B.
Right. The appellant's grievance is that award for acquisition of the land of the respondent number 1 was passed on 15/3/2024. And did it take into account the assessment, earlier assessment,
My lord,
crop assessment,
my lord,
which
it
Took-
had taken into account the 23rd March.
which
2000
took into
yes.
account the assessment of the crops damaged on the respondent number 1's land. The entire compensation amount was 12,72,480. Acha, just read it. Just read it once again. What have I said? Louder, madam. Ring the with it. The appellant's grievance. No. Please listen, I'll review. The petitioner's grievance, no, the appellant's grievance is that award for rupees 12,72,480 was passed by Kala on 15/3/2024.
2021, my lord.
2021, 15/3/2021, taking into consideration the assessment of crops damaged made on 23/3/2021. The approval for payment of rupees 12,72,480 was approved on 22/9/2021. First up. The compensation was also paid on,
My lord, release order was on September 22nd, 2020.
okay, no, the last sentence. Huh? No, but cut that. Before that, cut that. The last sentence. Huh? Now for damaged crops. to assessment of damaged crops made on 23/3/2021. No, not the approval. What is that you said?
My lord, this is the compensation release order.
The compensation release order was issued on 22/9/2021. Full stop. Next paragraph. Despite the award being announced on 15/3/2021 by Kala, and when was compensation paid?
My lord, I have not, this has not been reflected in the letter of the respondent.
You should know this.
My lord.
What have I said? The Deputy Commissioner had no, don't say that. A reassessment, the Deputy Commissioner, a reassessment on the damaged crops was again made on 14/10/2021, allegedly in pursuance to the DC's order. Full stop. However, the DC's order has not been shown or produced before this court. It is surprising that the DC/Kala, DC/Kala,
Your Lordship, if I may, the additional DC is Kala in the
it is surprising that the DC could have directed reassessment of damaged crops when Kala is the additional Deputy Commissioner, which district?
Khozol, my lord.
Khozol. Full stop. The surveyor's assessment of the damaged crops was made on 14/10/2021. Wherein it had directed payment of an additional 50, and subsequently, on the basis of the same, an additional 52,71,353 is to be paid by the appellant
Lordship, may I have
to the respondent. It is surprising that the said reassessment was directed to be made by a non-authorized person. Further, there is nothing to show that there has been any opportunity given to the appellant to cross-examine the surveyor with regard to the reassessment made. Next para. Ms. Lalnun Rui, Learned Counsel for Respondent number 2, shall produce the DC order on the basis of which the reassessment has been made and which is reflected. Ms. Ruth, Learned Counsel for Respondent number 2, and the Counsel for the Respondent number 1 shall produce the DC's order on the basis of which reassessment was made on 14/10/2021, which is reflected in the respondent's letter dated 23/8/23 at page 31 of the present appeal. You produce that letter, we'll see.
Obliged.
Item number 3.
Yes,
My lord, what happened, my lord, my copy, my lord, index and my lord, the paging are not matching, my lord. So I think, my lord, in code copy, some problem may be created, my lord. So I'll try to obtain a certified copy of the,
who's for the other side?
my lord, the first
No
time, my lord,
notice.
first time.
Okay, right.
Yes, my lord. Notice may be issued, my lord, then, my lord.
Mr. S.K. Medi, learned counsel for the... You have asked for adjournment all the time,
No,
3 times.
Yes, my lord,
Has prayed for adjournment on the ground that
my lord,
the pages,
small issue
the pages in his, What?
issue is very small, my lord. One clause is not applicable as per our view, my lord. And the arbitrator and the learned court below, my lord, so, as per them, my lord, it is applicable. That is 110 cc, my lord. As per agreement is there.
Okay,
my
what
lord.
have I
Agreement, my lord, is deleted, my lord.
Mr. S.K. Medi, the learned counsel for the, just listen, Mr. S.K. Medi, chair 0. Mr. S.K. Medi, the learned counsel for the appellant, has prayed for adjournment on the ground that the pagination of his petition does not match the pages given in the index. He accordingly prays for time to rectify the same. Next, the above being said, it is seen that Mr. S.K. Medi has adjourned this matter on all the occasions, on the 3 occasions that the matter has been listed before this court.
My lord, court copy is okay, my lord. My lord,
Mr.
court copy is
Counsel,
okay, my lord.
Mr. Counsel,
Court
you-
copy is,
you-
my copy is not okay.
so what? So what?
My copy is, my lord, so my lord, when I
So
argue, my lord, the paging
who
is-
is, Mr. Counsel, you're not
My lord.
listening. Please
Yes,
listen.
Yes, my lord.
You have adjourned this matter on 3 occasions earlier.
Yes, my lord. Yes, my lord.
You had enough time to rectify your problem.
Yes, my lord. That is true, my lord.
Then why should we not dismiss it? You're not interested in pursuing the matter.
My lord, next, my lord,
I don't think,
Sorry.
you go to Supreme Court.
My lord, sorry, my lord. This, next time I will, my lord.
What have I
The
said?
last chance, my lord. This last chance, my lord.
On the 3 occasions that the matter has been listed before this court. Full stop. Though this court is inclined to dismiss the matter as the only issue raised by the appellant's counsel is a prayer for adjournment, Mr. S.K. Medi has prayed for another time, another date as a last chance. On considering the prayer of the learned counsel for the appellant, let this matter be listed again after 2 weeks, subject to the condition that cost of rupees 5,000 should be paid, cost of rupees 5,000 is deposited in the registry of this court within a week from today.
Highly appreciate.
The cost shall thereafter be given to the Mizoram State Legal Service Authority.
Highly appreciate.
List the matter after 2 weeks. Don't adjourn all the time only.
Item number 4.
May it please, Balaji, I appear for the appellants in this matter. My colleague Karthik is also there before my lords physically.
Yes, so there is some AD card has been received from 1, 3, 4, 5 and 9. No
The-
unserved notice from 4 others. Now what to do?
Mullards, in my respectful opinion, we can try a dusty service if your lordship permits.
Okay. Right. Whose name do I put in? Mr.
Shubham Paliwal.
Shubham Paliwal. Huh?
Shubham Paliwal, my lords.
Mr. Shubham Paliwal, learned counsel for the applicant, prays that he may be allowed to serve notice upon the respondents number respondent number 2, 6, 7 and 8 as the office note dated 25/3/26 states that the same has been returned from the post office due to insufficient address. Full stop. The prayer of the appellant's counsel is allowed. Thus, the service to be effected within
It's 2 weeks.
2 weeks through the registry of this court, and affidavit of service to be filed thereafter. Full stop. Next para. The office note dated 25/3/2026 also states that duly signed AD card has been received from the respondents number 1, 3, 4 and 5. 3, 4, 5 and 9. Accordingly, full stop. However, no one appears for respondents number 1, 3, 4, 5 and 9. Notice is accordingly deemed to be served upon the respondents number 1, 3, 4, 5 and 9. List the matter on. List the matter after 2 weeks.
Item number 5.
Please, Mullards. This is arbitration appeal number 3. Mullards, in fact, in both these matters, 5 and 6, I was making a respectful submission that, Mullards, the entire arbitral record may be summoned because your lordships on the last occasion indicated to see that whether any evidence at all was considered, led or seen by the arbitral tribunal. Mullards, in my respectful submission, your lordships will then have to see the entire arbitral record, if that may be summoned.
Okay. We'll call for the arbitral records. From
Yes,
where?
my
Who
lord.
is the arbitrator?
Mullards, the arbitrator is
K. Lalrinswali.
Huh?
Mrs.
K.
K.
Lalrinswali.
Lalrinswali.
Okay, right. Counsel for the party. Mr. Shubham Paliwal is present virtually for the appellant. Mr.
Elgin Zothan Moya.
appears for
Respondent number 1.
1. That's all. Who's for the other? For
Kala,
two?
my lord. Kala.
Kala. Ms. Lalnun Dhui appears for respondent number 2. Kala. What?
For Kala Kolasib. Your Lordship, for Kala Kolasib, they have their own separate advocates, Your Lordship. They
Okay,
have their
who
own
is it?
counsels. Your Lordship, I believe they have not been appointed yet for this particular appeal, Your Lordship.
Right. No one appears for the respondent number 2. That is Kala Kolasib. Again here, no. Just see this AD card has been returned from the post office. Returned? How? Was it served, not served? Where is this person? Call him again. They don't give a proper report. Returned. Because we had asked for a detailed report, then they showed us this has been served, this has been signed, this is not signed. What have I said? The office note, next paragraph, the office note does not indicate as to whether the ID card that has been returned pertains to respondent number 2 and whether it has been signed by the respondent number 2. Next paragraph. The issue raised by the appellant herein is that the learned arbitrator enhanced the compensation amount without the same being based on any evidence. Accordingly, a registry to call for the records from the learned arbitrator or before the court, what?
My lord, if I may also submit.
Before the learned arbitrator or the learned district court. District judge scholarship. Additional district judge scholarship. Yes.
My lord, that was what I was trying to pray, to call for the records of the district judge.
So we are called.
Yes.
List the matter after 2 weeks.
Obliged.
So grateful.
Item number 6.
Yes, what is to be done here?
Malaj, it's the same submission, Malaj. Even in this case, Malaj has posed both these matters together, the same issue arose. So
Is
if
this is
Malaj
also
was-
scholarship.
Yes, my lord.
Same thing. Same order, ditto.
We are deeply obliged.
Next.
Obliged, my lord.
So good.
Item number 7.
Delay of 4 days.
May it please, Your Lordship, I'm
Yes, right. Heard Ms. Dalnun Reid, Learned Counsel for the applicant / State of Mizoram. This is an application for condoning the delay of 4 days in filing the appeal under section 37 bracket 1 bracket small b of the Arbitration and Conciliation Act, 1996, challenging the impugned order dated 15/12/25 passed by the learned district judge, Aizol in arbitration case number 7 of 2025. Full stop. Next para. On considering that the delay pertains to only 4 days, this court finds that sufficient cause for the delay has been made out. And is of the view that the delay of 4 days should be condoned. Full stop. Accordingly, the delay of 4 days condoned. I is accordingly allowed and disposed of. Next, in the main,
Much obliged, Your Lordship.
in the main appeal. What is this? How are you challenging?
Yes, Your Lordship. Your Lordship, this arbitration appeal is preferred by the state of Mizoram against the order dated 15/12/2025 in the arbitration matter 7 of 2025, Your Lordship, wherein the interim order has restrained the appellants from terminating the contract and invoking the bank guarantee. Now, Your Lordship, I will kindly be going into the history of the case, Your Lordship. Now, Your Lordship, the respondent is a Class 1 contractor who is awarded the work of construction of Meidum to Hortoki road pavement. And Your Lordship, the contract price is of rupees 23 crore, Your Lordship. Now, he had been awarded the contract on 25/7/2022, and the respondent was supposed to complete the contract within 12 months, and that is from 03/8/2022 till 3/8/2023, Your Lordship. Now, Your Lordship, this is a NABARD funded contract, and the hard deadline is of 31/3/2027, Your Lordship. And now the respondent has been given 3 extensions, and the cumulative number of extensions given is cumulated to be 763 days, Your Lordship. Now, even after 36 months, Your Lordship, only 9.2% of the progress has been made in the contract. And Your Lordship, now the
So have you terminated the contract?
yes, Your Lordship. In that regard, Your Lordship, the show cause notice and a show cause notice was
Termination done.
no, Your Lordship, not yet, because Your Lordship, they had applied under Section 9 to the Arbitration Act before the District and Session Judge, and Your Lordship, and based on that, and Your Lordship, that was the first application under Section 9, and in that, Your Lordship, the condition was given that okay, you both the parties within 90
Maybe
days.
Section 9, Arbitration Act.
Your Lordship, a show cause notice was given by the appellant on 1/7/2025 under Section 59 of the General Condition of Contract. And then, Your Lordship, the respondent had also filed a reply on the 11th of 7/2025, which is 10 days after the show cause notice was given. Now, Your Lordship, after which, on the 13/8/2025, the Chief Engineer, he issued a letter of termination. And also, Your Lordship, the invocation of the bank guarantee was also sent to the ICICI Bank on the same date as well. Now, Your Lordship, due to this, the respondents, they invoked Section 9 of the Arbitration Act, and then the judge gave them a decision which prevented the appellant from acting on the termination and invoking the bank guarantee on 2/9/2025. This decision was made on 2/9/2025, Your Lordship. Now, in that condition, it was said that this is on page number 206, Your Lordship.
No, so they went directly to the court, not to the arbitrator.
No, Your Lordship.
Huh?
No, Your Lordship. They went directly to the court after they had received the termination letter and the show cause notice and termination letter, and also when they.
Under what provision did they go to the court?
Your Lordship, under Section 9.
Okay, under Section 9.
Yes, Your Lordship, of the Arbitration Act.
So let us see the termination letter.
Yes, Your Lordship.
Page. There is an arbitration clause, but they did not go. They did not.
No, Your Lordship. And the onus usually falls on the applicant to invoke to initiate the arbitration tribunal, Your Lordship.
And this case is still pending before the learned.
No, Your Lordship. This has already been
disposed of.
Yes, Your Lordship.
And what was the final decision?
The final decision was that, Your Lordship, we have been.
So it is only a application under Section 9.
Yes, Your Lordship.
That's all.
Yes, Your Lordship.
There's no main case.
No, Your Lordship. Now, Your Lordship, now we have been kept in limbo. The project is also in limbo, and now the fund will also be terminated in 2027, Your Lordship. So, having no other option, we have opted for the appeal, Your Lordship, because we are not being allowed to terminate the contract as well, nor are we allowed to invoke the bank guarantee as well at this stage, Your Lordship. And there has been no initiation from the respondents to set up a arbitration tribunal as well, Your Lordship.
This cannot be. You have come under what provision of law?
37, Your Lordship.
Where's the 37? 34 has not been applied. So why did you come under 37? So this order, the interim measure was passed when?
Your Lordship, if the interim order
Was
the
passed on
first-
15/12.
the first interim order was on 12/9, Your Lordship.
12/9.
Second 9, 2025, Your Lordship. That was the first interim order.
2/9/2025.
Yes, Your Lordship.
Interim order under section 9, under 9E.
Under
Correct.
section 9 is what has been written in the order, Your Lordship.
Where is the order page?
Your Lordship, this is on page number 203. This is the first
Just a
interim
minute,
order.
just a minute. No, this order is completely wrong. Page 203.
203, Your Lordship. That is the next 12.
Give them the Arbitration and Conciliation Act. Have you got with you?
No, Your Lordship, but however, Your Lordship, under 37, we are coming under 37 because it is an appeal and challenging the interim order, Your Lordship. Hence 37.
20, page 203.
203, Your Lordship.
How can this order be done? How can you do this?
Your Lordship,
Then after this, when was the next interim order? Any other interim order? No.
yes, Your Lordship,
Which
there is
page?
another. That is on 15/12. That is the main.
That is the main order.
Yes, Your Lordship.
Now you see, have you got the Arbitration Act?
Yes, Your Lordship.
Come to 9.2. Come to 9E.
9E, yes, Your Lordship.
9.1E.
Yes, Your Lordship.
Such other interim measure of protection as may appear to the court to be just as convenient. That can be done. Okay?
Yes, Your Lordship.
Now come to 9.2.
Where before the commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceedings shall be commenced within a period of 90 days from the date of such order or within such further time as the court may determine.
So has it determined when it should, when the arbitral proceeding should commence?
Your Lordship, in the first order under the section 9, the condition was given that it should be set up under, in the last para, Your Lordship, that is page number 206. May I read, Your Lordship?
Yes, yes.
It says, accordingly as an ad interim measure, the termination order dated 18/8/2025 and order dated 13/8/2025 for invocation of bank guarantee, both issued by the respondent, shall remain suspended till further order. Needless to mention that as per section 9(2)(a) of the Arbitration
So
Conciliation
outside it
Act.
says that it shall be automatically vacated.
Yes, Your Lordship. It was yes, Your Lordship. It was automatically vacated.
Then
Now, Your Lordship, however, Your Lordship, thereafter, after the expiry of the ad interim order, which is 90 days, the respondent, with the intention to extend the protection further, applied for section 9 again, Your Lordship.
you cannot do that. Again, section 9.
Yes, Your
So
Lordship.
this is
The respondent
so
went under
this
section 9 again.
This section 9 is 7/25,
Yes, Your Lordship.
and this section 9
Is also 7/25, Your Lordship.
This is again. This is a different case, but same in the same thing.
Yes, and the
Two
same.
applications in the same case.
Yes,
number.
Your Lordship. Same arguments as well.
So let us see what is the final decision in this second interim order.
It is similar as the first interim order as well, Your Lordship. And then we have been refrained from terminating the contract and also,
No.
again, and also from encashing, from invoking the bank guarantee as well, Your Lordship. Now, Your Lordship, it is a public fund, it is a public project. Now the whole project is in limbo at this stage, Your Lordship.
No, we'll see. This is completely wrong. And this is still, what is the date of this order?
This is-
1512.
Yes, Your Lordship.
So that has expired again.
6 months have passed, yes,
So,
Your Lordship.
so we will make a thing that this entire thing is finished. There's nothing now.
Yes, Your Lordship. It has completely been exhausted, Your Lordship, the
But where
time
does
frame.
it say? But it does, out here, it does not say automatic dismissal or anything, no?
No, Your Lordship.
But will say that we will make it clear that nothing survives.
Yes, Your Lordship.
Okay. Right. Now, what is the contract? Where is the contract? Where is the contract is for what?
The contract is for road pavement, Your Lordship, from
Yes, Your Lordship.
Meidum to Hortoki, Your Lordship.
And it was supposed to be completed on
Your Lordship, on within 12 months,
112 months. And then and he has completed how much till date?
Your Lordship, only 9.2%.
9.2%.
Yes, Your Lordship.
And the term, okay, right. Heard Ms. Ruth, Lalundri, Learned Counsel for the Appellant / State Government, who submits that the impugned order dated 15/12/2025 passed by the Court of the Additional District Judge - Roman II, Aizol, in arbitration matter number 7 of 2025, should be set aside. Next part. The Learned Counsel for the appellant submits that the respondent had been allotted a contract work for construction of Meidum to Hortoki Road. You call madam, call the other stenos. Why you won't fit the Habatu in call the other steno. You'll go. What the road? They do to go. दिया कर दिया Is there any judgments, citations with regard to
Yes.
with regard to 9.2?
Yes, Your Lordship. We have quoted in the appeal as well, Your Lordship. However, if required, we may be asked.
What
allowed
does it
to
say? What
produce-
does it say?
Your Lordship, basically, if I may read out from the grounds, Your Lordship, we have stated that the guarantees are expressly unconditional and payable on demand, and the autonomy constitutes a settled principle of commercial law. The Supreme Court in UP Cooperative Federation Limited versus Singh Consultants and Engineer Private Limited in
No, that
19...
is with regard to bank guarantees. That's the difference.
Yes, Your
I'm
Lordship.
talking of under 9.2 of the Arbitration Act. There must be a judgment.
Yes,
that-
Your Lordship, there is a case. It's a Sundaram Finance versus any IPS. Your Lordship, if we may be allowed to produce the same on the later.
Get-
Your Lordship, we do not have the copy as of now. We can produce it today
Use your
itself.
phone. Use your phone to get it.
Yes, Your Lordship.
Where is Marfwai? Where is OP? What about OP? OP has got nothing to do. Nang banget ini orang kalbel. Okay, right. Of Meidum to Hortaki Road, phase dash Roman 2, for an amount of rupees 23 crores 98 lakhs 8,789 only. So, sir. The contract was awarded to the respondent on 20/06/22 and same was to be completed within 12 months. Next paragraph. Despite, despite extension of time being given to the respondent to complete his contract work for how many years? 2
Your
years.
Lordship, extension has been given cumulative of 763 days, Your Lordship.
Time had been given to the respondent for
63 days.
763 days
Yes, Your Lordship.
cumulatively, comma, the respondent had not completed his contract work. Which was to, which we completed first time.
It should have been finished on the 3rd/8/2023, Your Lordship.
The agreement between the parties had been entered into on 25/7/22 and the work was to be completed initially on 3/8/22. 3/8/23. As the work was not completed by the respondent, next para, despite extensions being given to him, extensions of time being given to him, the appellant terminated the contract work via letter dated 13/8/2025 with effect from no 13/8/2025 and sought invocation of the bank guarantees on the same day. Next paragraph. The respondent thereafter filed an application under Section 9 of the Arbitration and Conciliation Act 1996, hereinafter referred to as the Act, seeking interim relief from the court before initiation of arbitral proceedings. Vide arbitration application number 7 of 2025 before the district judge either. The court of the district judge Aizal thereafter passed order dated 2/9/25 in arbitration application number 7 of 2025, wherein it directed as an interim measure, wherein it suspended the termination order dated 18/8 or 13/8? What is this? Termination order, termination of the contract.
Yes, Your Lordship, that is on Annexure 10, Your Lordship. That is
13/8 or 18/8?
13/8/2025. 13/8/2025, Your Lordship.
So it is wrongly mentioned here as 18/8 in page 206 in para 10.
No, 13/8/2025. It is the same, Your Lordship. Same.
said
Same, Your Lordship.
It's 18/8.
No, 13/8, Your Lordship.
Is this 13?
Yes,
No,
Your
it's
Lordship, that is
18.
13, 1-3.
Okay. The termination order dated 13/8/2025 and order dated 13/8/2025 for invocation of bank
Bank
guarantees
Yes, Your Lordship.
submitted by the respondent. The Court of the District Judge further stated that the arbitral proceedings in respect of the dispute between the appellant and the respondent must be initiated within 3 months from the date of presentation of the petition under section 9, and if not done so, comma, the order granting the interim measure automatically stands vacated on the expiry of 3 months from the date of presentation of the petition. Was this presented to you all? Was it presented?
Your Lordship,
This order and the
Yes, Your Lordship.
and the application for arbitration?
Yes, Your Lordship.
It's presented to you?
Yes, Your Lordship. Now, Your Lordship, at this juncture, I would like to quote the case which
No, one thing. So why have you not initiated so he has not initiated the arbitration proceedings, neither has you.
Your Lordship, at that stage, within that 90 days, Your Lordship, the arbitration proceeding was initiated by the respondent. However, Your Lordship, now the conditions was that there should be 3 sitting arbitrators. Now, in the proposal, they had only proposed only one single arbitrator, Your Lordship. And Your Lordship,
Naturally, they will propose one, you will propose one, and the two will propose one, the third one. That is the way it goes.
yes, Your Lordship. However, Your Lordship, in that regard, now, Your Lordship, that is also, but again, Your Lordship, the initiation had been done, but however, it was also defective at this stage, Your Lordship. By the time they had already sent out these, now at this stage, Your Lordship, it is already defective, Your Lordship.
What is defective?
The 90 days and also Your Lordship, the proposal for the arbitrator.
No, it's not defective. Once a proposal starts, then it's there. If he has sent a letter to you proposing arbitration,
Yes,
then
Your
you have
Lordship.
got to act upon it. You cannot take advantage of your own wrong.
But Your Lordship, they also went to the court again under section 9.
Correct.
So again, that Your Lordship, again we were restrained from terminating his contract again. and
No,
also-
your contract is terminated. Where is the restraint?
Your
Okay,
Lordship-
it's stayed.
Yes,
It's
Your
suspended.
Lordship.
It's suspended.
Yes,
But
Your Lordship.
that first one is gone, and this is only for 90 days. It cannot go
Yes,
beyond
Your
90
Lordship.
days.
Hence-
So where is the section 9(2) citation? Any citation on 9(2)?
On section 9 to the 90 days, Your Lordship, the citation, that is, Your Lordship, this is on pair 19 of the case. This is Sundaram Finance Limited versus NEPC India Limited. The citation is, Your Lordship, 2008-1 SCC1. In this, Your Lordship, in pair number 19, if I may read, Your Lordship.
Yes.
It says here that when a party applies under Section 9 of 1996 Act, it is implicit that it accepts that there is a final and binding arbitration agreement in existence. It is also implicit that a dispute must have arisen which is referable to the arbitral tribunal. Section 9 further contemplates arbitration proceeding taking place between the parties. Mr. Subramaniam is therefore right in submitting that when an application under Section 9 is filed before the commencement of arbitral proceedings, there has to be manifest intention on the part of the applicant to take recourse for the arbitral proceedings if at the time when the application under Section 9 is filed, the proceedings have not commenced under Section 21 1996 Act. In order to give full effect to the words before or during arbitral proceedings occurring in Section 9, it would not be necessary that a notice invoking the arbitration clause must be issued to opposite party before an application under Section 9 can be filed.
Give me that 2008
2008.
1 SEC 1. What have I said? Last
Your
sentence?
Lordship, if I may, this is, I read wrongly, Your Lordship. This is the 1999 2 SEC.
1999 2 SEC.
Yes, Your Lordship, 479.
1999 2 SEC
479, Your Lordship.
479. You get that?
Parent number 19 is the relevant paragraph, Your Lordship.
Yes, whatever you said. For, 3 months from the date of presentation of the petition. Next para. The relevant paragraph
Wait.
8, 9, 10. (11) and 12 of the order dated 2/9/25, passed in arbitration application number 7 of 2025, is reproduced herein below as follows. Page 206. Yes, madam, but this is says here, put up again on 29/9/2025. Page 206 at the bottom.
Yes, Your Lordship.
So it is not disposed of. What happened on
But then at the
29/9?
same time, Your Lordship, at this stage, if it was not disposed, Your Lordship, why was there a reason for the respondent to go under Section 9 again?
Leaving that aside, let us don't question. You see, the issue is this. This petition has not been disposed of. What happened on 29/9/2025?
Your Lordship, I have not been informed about the...
Yeah, but you have to find out.
Yes,
It's
Your
not
Lordship.
disposed of for written objection. Then what happened? Is it that they filed a separate? Is it that again an order for another 3 months has been given or what? We don't know. Where is the
Your Lordship,
disposal of this case?
But
This case has been disposed of for the first time by the impugned order only.
Yes, Your Lordship.
Not by this.
No, Your Lordship. And now, Your Lordship, after the respondent had issued a notice invoking arbitration on the 6/11/2025.
So you see, as per this page 206, page 10,
Yes, Your Lordship.
para
12.
para para 10, the arbitral proceeding in respect of the dispute must be initiated within 3 months.
Yes, Your Lordship.
Now, when was it initiated?
Your Lordship, this was initiated on the 6/11/2025 by the respondents.
6/11/2025.
Yes, Your Lordship.
Where is that initiation?
Your Lordship, we do not have a copy, however, that the same has been reflected on the para number 15 of the appeal, Your
Then,
Lordship.
so what has he asked? He asked for an appointment of para number 15.
Yes, Your Lordship, but only of the sole arbitrator, Your Lordship. And now, Your Lordship, he noticed proposed appointment of a sole arbitrator in departure
Para
from clause.
15, where is para 15?
Your Lordship, para number 15 is on page number 8 of the appeal. Now, Your Lordship, on this part.
Let us see the letter. You see, these are only your submissions.
Yes, Your Lordship.
Now, where is the proof of this letter? How do we know? This is the crux. Because if he had asked for 3-member,
Yes, Your Lordship.
now let us see your agreement for arbitration. Where does it say? Agreement for arbitration.
Your Lordship, that is on.
Where is your agreement clause? Arbitration clause. You have said that it should be a 3-member arbitral tribunal. Where is that?
This is on, Your Lordship, page 115.
Yes, where does it say?
Your Lordship, that is section B, if I may read, Your
Okay,
Lordship.
the arbitral shall consist of
3 arbitrators, 1 each to be appointed by the employer and the contractor. The third arbitrator shall be chosen by the 2 arbitrators so appointed by the parties and shall act as a presiding arbitrator. In case of failure of the 2 arbitrators by parties to reach upon a consensus within a period of 30 days from the appointment of the arbitrator appointed consequently, the presiding arbitrator shall be appointed by the Council, the Indian Roads Congress, Your Lordship. That is.
Okay. Now let us see his letter.
Your Lordship, we have not.
You have to bring the letter because that is the main thing.
Yes, Your Lordship.
I want to see whether his letter, this notice,
Yes, Your Lordship.
whether it has really asked for only 1 arbitrator or 3 arbitrators.
Yes, Your
If it is 1, then you have got a case. If it is 3, then you don't have a case because you have to act upon that.
Understood, Your Lordship.
And you get that letter.
Yes, Your
We'll
Lordship.
take it up after at 2.
2. Yes, Your Lordship.
At 2 we can take it up. Okay.
Yes, Your Lordship.
So what have we said? Next para. Okay, and then you also find out with regard to this
28, the
29.9
yes,
that,
yes, Your
that
Lordship.
what happened? What happened? Is it a continuation? Was it ever disposed of that earlier application? I don't think so because it disposed, but now it is disposed of by another court.
Yes, Your Lordship.
So that you find out that.
Yes, Your Lordship.
You during lunch you can go find out.
Yes,
Okay.
Your Lordship.
At 2 o'clock you find out in the meantime. So I think there are 2 things there were. One is
Yes,
the
Your
letter,
Lordship.
one is the notice,
And one is the
and as with
order.
regard to that 29.9, what
Yes.
has happened? When did
Yes,
it
Your
end?
Lordship.
Did it ever end? Get all the orders
Yes,
of
Your
that.
Lordship.
You go.
Hello. Hey, why? Thank you.